Shraddha madam.
Hello, madam.
Can you please unshare so that when sir madam is joining, then we can start with
Okay, madam.
the sharing. Yes, ma'am.
Yes, madam.
Madam, I have already joined. Now I'm here.
Should I start, ma'am?
No, ma'am, I have called sir. Sir is just joining in 2 minutes.
Okay, madam. Okay.
Advocate Bajpayee sir is joining this meeting. So after sir will join, then we
Yes.
will start now. Yes.
Yes, ma'am. No problem.
Yeah.
So, madam, without any formality, directly we will start madam's lecture. Huh?
Yes, ma'am. Yes, ma'am. Okay. Hello, good evening, ma'am.
Madam, please start it.
Yes, ma'am. I just talked with sir. He is joining, and he said that let the lecture start, ma'am. Yes, ma'am.
Ah,
Yes. Uh, Respected Principal, Madam, Dr. Poonam Nathani, today's resource person, Ms. Shraddha, Assistant Professor Shraddha Choudhary, Madam, and all the teaching faculty members, as well as all my dear students. I welcome you all to this lecture series. And this is one of the important quality initiative of the internal quality assurance cell of our college. It is guided and inspired by the guidance of Advocate Shri Bajpayee sir.
तुमचा
And
कोणाचा तरी आवाज येते बंद कर.
today we are starting with this lecture series. So I first, without taking much of your time, I would like to give this charge to today's resource person. With your permission, ma'am, we'll start with the meeting. I request
yeah.
Assistant Professor Shraddha Choudhary, madam, kindly take over it and you can start with your lecture, ma'am.
Yes, madam. Thank you. Thanks a lot.
Yes, ma'am.
Am I audible, ma'am?
Yes, ma'am. You're clearly audible, and of course, you have shared your PPT also.
Okay.
It is visible in the screen, but just present the PPT, ma'am, so that we can check.
Yes, madam.
Yes.
Okay. Uh, Thanks for this opportunity. Today, we will discuss on the legal and moral dilemmas in the hit and run cases. Okay. So now let's see. As we are becoming the developed nations, today we are confronting the number of problems, which in that problem, this is very important aspect to see the hit and run accidents. Okay. Now let me ask you one question that Do you feel safe while walking or driving on a road? So the answer is not always yes. Many times we don't feel safe while walking or driving on a road. Okay. So why this is happening? Can you just tell me any reason that why we don't feel safe? Because of the road conditions, because of the speed of any motor vehicle that can be hit us. There are many other aspects also that we don't feel the safe on the road. Okay, so now we will tackle the one aspect, that is the hit and run. As we all know, as we all were the witness of the one road accident this year, a juvenile son of a real estate businessman hit a girl and a boy behind the Porsche, behind with a Porsche in a Pune, and he fled the scene. Okay, so this is a very famous example of a hit and run. Again, recently we have seen one example, that is a BMW hit and run case. Or similarly, we can say in June, Rajya Sabha MP's BM Rao daughter ran over a man on a Chennai pavement, okay, with BMW. In both the cases, the accused fled away from the scene. Okay, so see, this is the Mumbai BMW hit and run case car which hit the other cars, and this is the Pune Porsche car accident. Okay, now we will see the data of the hit and run accidents. India's hit and run problem is nearly 30% of India's road accident cases, which were caused the death uh, from the hit and run cases. Okay, so now we have to know what is the hit and run. Okay, see, the hit and run is defined as incidents where the perpetrator means a person who is accused for that particular crime, flees the scene without reporting the incident to any authority or without helping the victims. These cases have been today we can see these cases have been on the rise from as compared to the past decades. Okay, so let's see, one IIT Delhi's road safety report said that number of fatalities due to road accident is underreported, and many of those, or we can say many of those were without cited, without 40% of the higher than the data indicates that such road accidents were unreportable. Okay, now we have to see now we have seen the problem, what is the hit and run, and how this problem is arising day to day in this current situation. Now we will see what are the legal provisions for the hit and run in India. Okay, so there are many legal provisions in before this BNS. We can see these provisions in the IPC. This some of the provisions of legal, some of the provisions of hit and run in a Motor Vehicle Act also. Now we will go on the provision which was before this BNS, Bharatiya Nyaya Sanhita, which is the section 304A, that is causing death by negligence. Okay, so in the IPC there was no direct mention of driving scene or the death or case which was by the negligent or rash driving, but there was a section which only gives the discussion regarding the whoever caused the death of any person by doing any rash or negligent act which is not amounting to culpable homicide, but it amounts to the death. So the punishment is only for the 2 years with fine or both. Okay, now we can take a famous example of the hit and run case. That is the landmark case of a state of Maharashtra versus Salman Khan, which was highlighted the lacuna in the existing law related to the hit and run incidents. Okay, so initially he was convicted by the trial court, but after Bombay High Court judgment, he was acquitted. Okay, whose actions resulted in the death of one person and serious injury to the several others. Okay, but this law was not sufficient to give the punishment. Okay, now due to this inadequacies in the provision of IPC, many persons who were involved in the hit and run incident used to simply choose the run away. Okay, so there was no provision regarding that you should help and how you will punished by the court. Okay, so there was a lacuna. That's why we have come with the new sections in the BNS, that is section 1062. Okay, we will come towards the Motor Vehicle Act later on. Now we will see the section 106, which is relating to the causing death by negligence. Okay, so first we will see the section 106 subclause 1. The bare reading of this section says that whoever causes death of any person by doing any rash or negligent act. Okay, so in section 106 subclause 1, there is no mention of a driving. It's just only gives the it just only gives the idea of any rash or negligent act. Okay, and if a person is doing any rash or negligent act and which affects to cause the death of other, that person will be punished with the imprisonment, with imprisonment of either description of the term which may extend to 5 years or shall also be liable to the fine. And next, it has given the provision related to the medical practitioners. If the medical practitioners negligence act will cause death, then they will punish with the 2-year punishment. Okay, now see the section 106. Here clearly they have mentioned that driving negligently, if a driving negligently causes a death, then what will be the punishment? Okay, now see the reading of this section 106 subclause 2, that whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide. Okay, it is not a culpable homicide, obviously, because this is a rash and negligent driving which caused the death of that particular person. Okay, so now we have to focus this line, that if that particular person escapes without reporting, okay, that particular person is escaping without reporting to a police officer or a magistrate, then he will be punished with the 10 year of imprisonment. Okay, so this is the lacuna. As per my opinion, this is the lacuna of this section. Why you are punishing a person for which because here we can say this is not a murder. Okay, this is a negligent act, this is a rash driving act which causes the death of person. Obviously the cause or the effect is the death, but this is not a murder. Still we have incorporated the 10 year of imprisonment in this particular section. Okay, and if we go, see here, if you are reporting, okay, so explanation of this section simply says that if you are reporting, then your punishment will be decreased. If you are not reporting, then your punishment will be the 10 years. Okay, so how we can say that, don't you think this is indirectly a self incrimination? Yes, this is indirect self incrimination. Okay, how? Because you are enforcing that particular person to come and accept your crime. Okay, so now I want to say that this section is totally against the base of criminal jurisprudence. How this is against the this section is against the criminal jurisprudence base? Because criminal jurisprudence says that no one can be forced to do self incrimination. A person who is accused of that act is the innocent till proven guilty. Okay, and now here in by adding this section, you are directly telling that particular person, come accept your uh, uh, accept your crime and get punished for the fire. Do you think anyone will come forward and accept their crime? No, no one will come forward. Okay. So this is a lacuna, I can say. You cannot force the accused to go and give the statement. Okay. Even as per my opinion, I think we can say if that person wants to help the victim, but he will not help. Why? Because he is in a fear that he will be convicted, he will be get the punishment. Okay. Now, okay, we will come on this slide again. See what section 134 of Motor Vehicle Act says, that duty of a driver in case of accident and injury to a person. See, this is the Motor Vehicle Act 1988, where duty of drivers have already given that provide medical attention to the victim, provide information to police, and provide written information to the insured. Okay, so incorporating this by incorporating this section, you are automatically saying that this is your duty. If driver has caused the death of any person, that he should give the medical attention, he should provide the information to police. Okay, but we are incorporating this section 106 subclause 2, and telling that if you are not informing, then you will be punished with the 10 years of the imprisonment. Okay. Okay, there is another section relating to the rash driving case. That section 281 of the Bharatiya Nyaya Samhita deals with the rash driving or riding on a public way that endangers the human life. Okay, so now compare this both sections, section 106 subclause 2 and section 281 of the BNS. Okay, in section 106 subclause 2, we see, or our focus is on a death. Okay, when a person will get a death, or a victim, on the victim's death, you are focusing that you should report. Okay, such reporting contravenes the spirit of Article 20 subclause 3 of the Constitution, which immunize a person accused in a crime for self-incrimination. Okay, instead of fostering a sense of retribution. Okay, so here this BNS is fostering a sense of a retribution. Okay, and it is not promoting, it is not encouraging the medical assistance. And here, for the rash driving, for such rash driving or a riding on a public way that endangers the human life, you are giving the punishment of only 6 months in a prison. You are imposing fine of 1,000 rupees. Okay, so now I want to ask you a question, that death. Okay, so death is a big thing, but does it increase the does it increase the does it increase the sufferance of the any permanent injury or any disability of any part of the body? Okay, so here, if you are getting the disability of any part of the body, or if you are getting the permanent injury, you will punish, means the accused will punish for the only 6 months, and he will get the fine of up to the 1,000 of the rupees. Okay, now why this section is incorporated, why such provision is incorporated? To enforce moral responsibility. But you are enforcing moral responsibility here by creating a fear. Okay, we can say that the positive aspect of section 1062 is that that particular person should help. Okay, that particular person should help the victim. But how that person will be help the victim if the death is causing? Okay. Let's see another example. See, Here you can see an image that a red signal is there, but still people are moving. Okay, do we follow this? Do we follow? Always we don't follow. Why we don't follow the red signal? Although it has imposed the sanction. Okay, in Maharashtra, if we are crossing the red signal, we will be fined with the 200 rupees. Okay, in state by state, the penalty is different. The fine is different. Okay, in Delhi, if you are crossing the red signal, you will be imposed the fine of 1,000 rupees. In some of the state, it will be 500. Okay, so this is a law, and this law is backed by the sanction of fine. Okay, but now see the another slide. Do we follow this? If black cat is crossing our way, do we follow? Yes, we follow. Okay, we don't go, we don't move forward. Okay, why? Because it is our inner morality. Okay, see, laws which prescribes the external conduct, whereas morals prescribe the internal conduct. Okay, so the red signal is a law which prescribes how we should act, how we should move forward. Means by seeing a yellow light we should stop, by seeing a yellow light we should see that what is happening there, by seeing a red light we should stop. Okay, these are the external conduct laws that we should follow these laws. But the inner morality, which is not backed by any sanction, is there any sanction if you are going forward by seeing a cat? Is there any problem? Is there anyone who will impose a fine on us? No. But still we follow. Okay. That is, the morals alone are concerned with the subjective factors such as the motive. The moral is the one thing that increase our motive. Okay, so now we can say that yet even morals are not without a sanctioning element, still we follow because of the societal pressure, because of the this is very powerful pressure that we think that person what will think about us. Means our many things are there which we do only because of the morality. There is no any sanction, like our food choices, like our clothing choices, like we do the religious activities. Okay, so there is no any sanction, but still we follow. But when we drive on a road, okay, we know that if I will drive, that will endanger to other person's life, that will cause any person's death, but we'll still don't follow. Okay, because of the our inner morality. So the morality is very important while the things, but morality is important, but does moral alone can do the change? No. Okay, so this is very famous line that the thought of a man is not a triable, for the devil himself knows not the thought of a man. It means that no one can predict what is man is thinking, what is it's his morality. Okay, even devil is not aware about this, that what we are thinking. Okay, that's why it is a settled principle. So this line I have taken from the one famous case in England, that in England and Malta, the settled principle in this matter is that every same adult is presumed to intend the natural or necessary consequences of his willful conduct. It means simply, it means that we know what will be the result of our conduct. Okay, and by knowing the result of our conduct, if we are doing that thing, then we should be punished. Okay, see this slide, we know what will be the result of crossing this signal, but still we cross, so we will be sanctioned. Okay, so the penalty will be imposed on us. So the proponent jurist Immanuel Kant also says that we should not act out of a we should act out of a goodwill, but not for the rewards, not for the punishment, but because the things are right, then we should do that particular thing in the right. Okay. Now come to the point that I'm making the link between these two things, section 106 and our morality. Okay. See, the question is, however, can a person compelled to be witnessed against themselves? Because this is a very big issue that we cannot compel anyone for their wrong act. Okay, but we can do a thing that we can uh, emphasize on the golden hour. Golden hour means what? When a person hit to another person and that victim is in a golden hour, means if that victim will get the assistance, medical assistance, then there is a chances, there are more chances that he will be fine, he will be okay, or there will not be any fear of a death. But this section, okay, so tells that uh, 201st Law Commission's report also gives that the Law Commission emphasized on the need to provide swift medical aid to the victim in the critical golden hour, which can prevent the 50% of the fatalities. Okay, and we should encourage the bystanders. Bystanders means who? People around there who are present at that time. So it is the duty of those people also to assist the medical help, medical aid. Okay. Okay. While we are discussing this section 106, which we are talking about, that it is not the correct section and there is a lacuna in this section. So we have to see as the part of a driver's point of view that 10 years of imprisonment is and hefty fines are not correct, because many drivers, so basically we will take an example of the truck drivers. Okay, so we cannot blame alone the truck drivers for such incidents or any drivers for such an incident. And there were one protest also before applying, before uh, before incorporating this law in the draft, where the draft was made, there was a there was a protest by the truck drivers, which they were arguing that we alone are not subject for this particular, we alone are not the um, subject for this particular crime, because there are many long driving hours, difficult roads are there, then some of the factors are beyond our control, poor visibility due to fog, then fear of mob violence was also is also there. So that's why this is very unfair. And I want to make a suggestion that if you are blaming only to the drivers, then this is not fair. And if when in BNS or in IPC, as we know that there are a number of crimes, okay, and those crimes are categorized. Okay, so today this problem or this issue or this thing, every day we drive, every day we move from one place to another place. Okay, so this is very needful that it should be the categorized. Okay, so this act or this crime should be categorized, and there should be a particular punishment, and there should be appropriate punishment for such a crime. But here we can see it have given only one section regarding the rash and negligent act, and which is also dealing only with the death, which is not dealing with the grievous hurt, which is not dealing with the heart, which is not dealing with the accident or any contributory negligence. Okay, so that's why this is also a very big problem in this act and as in this section. Okay, but today this section is on hold, this section is not applicable. This is very important point. This point we should note that uh, as we all are witnessed that from 1st July 2024 we have applied this BNS, but section 106 subclause 2 is on hold because of the many protests, because of the insufficient language of this particular section. Okay, So now we have talked about more on the lacuna of this particular section, but we have to give our focus that what should we do, okay, to tackle this problem. What should we do? So moral responsibility of driver, that every driver has a moral duty to stop and assist the person involved in an accident. Then fear versus responsibility, we will see the two things, that is a fear and another thing is a responsibility. Fear of punishment, obviously one can fly away because of the punishment fear, but still it is our ethical duty that we should help, and without the thinking of our self preservation, and we should do the right things. Okay, now we will see the compensation dilemma. Okay, because here we can see and we can join the all points that only gives the punishment. Okay, so what about victim? So what about the victim's point of view? Because in section 106 subclause 2, in a draft, not in act, in draft they have mentioned the fine of up to 7 lakh rupees. Okay, so that fine should be given by the accused. Okay, and that fine will go to the government. Okay, but what about the victims? In a compensation dilemma, earlier provisions were about because compensation provision was given only in the motor vehicle act, not in this BNS. We will see the compensation under motor vehicle act was limited up to the 25,000 for death and 12,500 for the grievous injury. And after Motor Vehicle Amendment Act 2019, this fine is this compensation is increased. For death there is a 2 lakh, and for the grievous injury there is a 50,000. But we can see that does fine, does compensation justifies that particular act? Can we evaluate? Can we give the can we make prices of person's life? No, we can't. And despite increasing this much of the compensation, we can still see that these compensations are very inadequate in the many cases. Let's see the reform measures or steps for legal and policy reforms. Which measures should be taken for to change or to amend this provision? So first is, yes, penalty should be there. I'm not against with the penalty, that only morality and only other things cannot tackle this situation, okay, this problem. But penalty or penal law should be justifiable. Those should be justifiable with the death, that should be justifiable with the hurt, that should be justifiable with the grievous hurt and others. Okay, so such laws should be justifiable. Another major or another step we can take, that is use of a technology, CCTV cameras, traffic monitoring system, and use of GPS to track offenders. These can also tackle this problem. Then strengthening the witness protection program. Okay, many times witnesses don't come forward because they think that they will also involve in the case. Okay, so the police machinery will make that they are also involved in that particular case. That's why witnesses don't come forward. So we have to encourage people. We have to encourage people and make them to come forward without any fear or harassment, without any fear of get involved in that case, without any harassment by the, if they are uh, uh, if they are aware, if they are know that they will not harassed, then they will become forward. Okay, then we have to incorporate the morality and in a driving lessons also, that traffic safety education, that one person should help to another person or accused will help to the victims, etc. So these measures can tackle this problem. Now see the, now we will discuss the duties, that legal versus moral duty. Okay, so legal obligations alone cannot resolve the problem, as we know, because always we don't follow the legal things, but as a moral responsibility we follow the things, we do help to another persons also. Then the collective moral responsibility, in collective moral responsibility, society will, society as a whole must value the human life in assess the accidents, upholding the both legal and moral duties. Okay, so society plays very important part. Okay, so many times we can see that the society or the other peoples are there who does the mob lynching. Okay, so this is also very important point, that an accused flies. Why that accused flies? Because of the fear of a mob lynching. Okay, that he know that if I step down of my car or my vehicle, and if I go to help the victim, that mob will do mob will attack on me. Okay, so our as a social responsibility, we should not attack on the accused, we should help that victim. So this is also very important. If this fear will go away from that accused person, then that he will be okay, that person will came to help. Okay, so now I want to ask a question, that are you familiar with the Good Samaritan law? Do you know that what is a Good Samaritan law? Okay, so from this picture, yes, anyone is there?
Anyone who wants to participate and talk here can just raise your hand. And I think the mic is also allowed. So you can participate.
Okay, so by this picture, we can get an idea that is the Good Samaritan law. Samaritan law means that nothing but as a bystander, as a third person, when we are helping to the victim, we will be that our felicitation will be done by the government, and government will give recognition that we have done this type of help. Okay, so this is a Good Samaritan law, that it promotes that a civil society, that how we should live in this civilized society. Okay, so here I want to quote one line by the Roscoe Pound. Roscoe Pound says that law is a social institution to satisfy the social wants. Okay, so law should be always for the society. Okay, that law should not give the fear of the society, but law should give the promise to the society that these laws are for them. Okay, so Martin Luther King also quoted one time that if law and order uh, is preventing society's development, then such laws and orders are not for the society, and thus these laws and order will become only the watertight compartment which stops the flow, which stop the flow of development. Okay, so by seeing this law, we can say, take an example, if such strict laws will be imposed, then how this society will run? No, as we know that drivers or truck drivers truck drivers plays very essential role in our day-to-day life. Okay, we order something online, we then that particular parcel come from the Pune, from the Mumbai, from Delhi, and it comes to us. Okay, and if we are imposing such strict laws, okay, so how they will work? Their livelihood is depend on this particular profession, on this particular job, and we could not give them a protection. Then how the society will work? Because society is not for the only for a particular part, but society is for whole. Okay, so but laws are for whole the society. लॉ हे सगळ्या सोसायटीसाठी आहेत, सोसायटीच्या एका पार्ट साठी आहेत का? नाही. The law should treat everyone equally. Okay, but lacuna is also there in section 106 subclause 1. They have given punishment for the medical practitioner for only 2 years. Okay, but they are giving punishment to rash and negligent driving up to 5 years, up to 10 years. Okay, so here laws are making the inequality. Law is making the inequality between the two individuals of the society. Okay, so now see, the law is a social institution which satisfy the social wants. So law should be in that way that it should fulfill the all social wants, all people's wants. Okay, now let's move on the last slide of this session, which will conclude the whole discussion. Okay, so Justice Krishnan Iyer in All India Judges Association case, they have quoted these lines. See, law is a means to an end. Okay, and justice is that end. If law shoots justice, the people shoot down the law. And lawlessness paralysis development, disrupt the order, and retard the progress. Okay, so while you are building a law, you should keep the balance between the society. You should keep the equitable interest of this society. And this law is made for the justice. And that justice should be served to the two parts. It should be served to the victim part also, and it should be served to the accused part also. Okay, law should not make the biasness between the victim and accused. Okay, and if such laws shoots the justice, the people should down the law. We all are the victim of such laws, like the farmers bill, like this section before before making this law, when this was a draft, there were many types of a protest. Okay, and it makes to hold this law because people have that power to shoot down the law. And if the state is lawlessness, then the development will be paralyzed. Does development will increase? No. Okay, and such a disrupt order and retard, and it will give an effect in the disrupt order and retard the progress, and which is not good for the development and welfare of the society. Law has to be justice oriented and people centric. Okay, so this is the last line, that every law should be the justice oriented and a people centric. Okay, so as I have given my point of view and the dilemmas in justice, in dilemmas in the laws and the morals, we have discussed this all things. What do you think? Now I'm open. Now I'm giving you the opportunity and requesting you that please give your opinion on this particular section and the dilemmas which we have discussed in this hit and run case. Okay, because this is speaking about, this is not an accident case. Okay, This is hit and run. Means you have hit someone, you have done that act, and you are flying away. So one should not fly. Yes, obviously one should not fly. But why he is flying? And if you are making such laws, then why he will not fly? Obviously he will fly because you are not protecting. And you are protecting that person, but you are telling him that you will punished. When you will proven guilty, you will punished for 10 years. Okay. And uh, uh, if you come, okay, if you come and tell us that I have done this act, you will be punished for 5 years. Then why that person will come? Does he come to take the punishment of 5 years, or he will fly? Okay. Now I am requesting all that you should give your opinion that such this provision is made for what purpose, and it can have it positive sides, but I don't think there is more positive sides. Only one positive side is that um, one should not fly and do the aid, give the aid to that particular victim. This is a positive side, but
Yes, madam. Ma'am, thank you very much because you have focused on so many important dimensions of this particular section. And of course, there are legal consequences, there are moral and social consequences also. And we
yes,
had a
sir.
360-degree view of this particular section itself. We have also put up so many questions for us to discuss and delve upon. So I will also appeal the participants that if you want to have a discussion, please raise your hand. I have one person raising the hand, Mr. Dhananjay.
Yes,
Please unmute your mic and you can participate.
Thank you
Shraddha
for
madam, can you
allowing me to
please
participate.
start your camera?
Hello. Can you
yes,
hear me, madam?
yes, yes, I can hear you.
Thank you for allowing me to participate in the whole program. May I request madam to bring in the slide 106 section subsection 2 again back again
Yeah,
on
yeah.
the screen.
Okay, okay, okay. Just wait for a second.
Yeah. Here the
Sorry.
section
Uh,
reads.
this is section 106 subclause 2.
Yeah. It reads. Whoever causes death of any person by rash or negligent driving of vehicle not amounting to culpable homicide and escapes without reporting to it to a police officer. Now here the person is needed just to report the case, not to confess the
Yeah,
case. Here whole of the interpretation of the section, I think what madam has interpreted, I beg to differ from her opinion. The person
yeah.
who has caused the accident is to just to report the case. It is not that he should admit that he has committed a crime. So
Okay.
this is a section
So,
which is basically preventing from hitting and running away from the scene.
yeah.
Yeah.
Hmm.
So that is my
Okay.
interpretation. So whole of
Okay.
the
So,
I mean uh,
yeah.
yes ma'am,
So,
please continue.
reporting. Okay.
Yeah,
So, what he is
just a report.
reporting? Yeah. What he is
He's
reporting?
just to report. He is just to report that an accident has happened, and that is it. That's it. It is not
Okay.
to admit that
So,
he has committed a mistake or he has committed some certain crime, or it is by his own mistake that the crime has happened. Crime might have happened even by the pedestrian as well. He might have come by a wrong way before the vehicle, and the vehicle must have hit him. So that is a case which is to be tried in a court of law, right? So
Right.
in the police station, he has not to admit that he has done certain mistake. He has just to report it. And I think that section 106 subsection 2 is meant to prevent the flying away of the, I mean, the accused or whatever you may call him accused, call a person
Yes.
accused. Yes.
Yes.
So
I'm also
the
focusing
whole,
on this
I mean,
point
the whole,
that
this is not a lacuna, which to my mind, I feel that this is not a lacuna. In fact, it has strengthened the provisions of the earlier IPC.
okay, sir. So earlier IPC section 304 subclause, sorry,
It is
section
mentioning
304.
any negligent. It is mentioning any negligent act. Any negligent act covers even the rash driving. Any is a very broad spectrum term which is covering any negligent act, and in that any negligent act even the rash driving comes, right? So now this is the subsection 2, insertion of subsection 2 is basically to strengthen the prevention of the flying away of the accused person from the scene and from the police machinery, law machinery, you may call it.
Okay. So
So this
section
is
A.
how can this be a lacuna? In fact, this cannot be a lacuna.
Yes, sir.
And
Sir, did you
this
complete?
please,
Yeah. Can I? Yeah. So
please.
section 304A speaks
Hmm.
about only the negligent or rash act which punished for the which have given the punishment of only 2 years. And in section 1062, as you are saying that a person escapes without reporting it to a police officer or a
Ah,
magistrate soon. Okay. So
yes.
if that person is reporting that the incident was happened by him, what he will report?
No.
That
You are
person,
mistaking it.
no.
Let me clear myself. Let me clarify myself. You see, reporting does not amount to admitting a crime. Reporting doesn't amount to admitting a crime. See, if I am reporting certain thing, that it doesn't mean that I am admitting that I have done it.
Then what he will report?
He will just report that an accident has happened. That's it. By my vehicle. That's it. Simple.
From my vehicle, it means that
Of course.
he have done that particular act, no?
No. That
Then who
doesn't
will
amount.
who have done that
Look,
act?
madam. Look, fault may be from pedestrian side, fault may be from the driver's side. Both.
Yes,
Right?
I'm also yes,
Yes.
sir. I'm
Now,
also
now, now,
emphasizing on that
now, now,
particular
let
point
me complete my
that
statement. Ma'am, please allow me to complete my statement. Now, the fault might be from the pedestrian side, fault might be from the driver's side. Now, this is a point which is to be proven in the court of law. The burden of proof, of course, is on the prosecution itself. It is not on the driver, because driver is just an accused. Right? So he is not to admit
yes, sir.
anything, he is just to report it. That's it. And if he doesn't report it, then the punishment will, then the crime will put the burden of the proof on the driver itself, because he has fled away from the scene.
Yeah.
So that's why the punishment of 10 years.
Okay, but in a reporting that he have to report that this scene was happened or this particular accident was happened by my vehicle and by other person's vehicle. Okay, yes, I'm also focusing on that point that contributory negligence can be done. Okay, so this is not a scene of a contributory negligence. This is now you are pointing only on the reporting part, but let's see here death is happening. Okay, and always who see when a person hit another person, okay, or by that his vehicle, then he will be accused. I'm not telling that he is a criminal. He is accused.
He is going to
Okay,
be
he is
accused in any
accused.
case, madam.
Yeah.
If he flies
Now
away
let me
from the
complete.
scene, he will be accused. If he doesn't,
Now
he
let
will
me
be accused.
complete.
In any case, he will
Let
be
me
accused.
complete, and this
Please,
discussion
please.
will we
Please go ahead,
continue.
ma'am.
It can be continue after this lecture also. Now I'm telling here that a death is caused there, and that person is reporting. Okay, then he is accused, and while he is accused, if he will proven guilty, then he will get the punishment of 5 years. And if he flies, then how you will uh, identify that person who was the accused? If he flies, then what? How you will give the punishment of 10 years?
In fact,
How you will
his
prove?
action, I'll
Yeah,
tell you.
that's why I'm
His
telling
action
here
itself.
that this is
Let, excuse me, sorry for interruption. Sir, please let her complete
Okay,
the.
okay, okay. I'm sorry.
You are
I'm
not
sorry.
allowing her to
In fact,
complete.
काय झालं ते थोडंसं I'm
Sir.
sorry. I won't speak.
okay.
Yes,
So
madam.
let's see. Yeah. आता बघा सेक्शन 106 सब क्लॉज 2 जे आहे हे काय सांगते की एकदा का डेथ कॉज झाली. बघा इथं शब्दच जो वापरलेला आहे तो डेथ आहे. हा, डेथ खूप इम्पॉर्टंट शब्द आहे. डेथ कॉज झाल्याच्या नंतर तुम्ही रिपोर्ट केली तर तुम्हाला 5 वर्षाची रिपोर्ट केल्याच्या नंतर नाही, रिपोर्ट करतात म्हणजे तुम्ही अक्युजच आहेत. जर तुम्ही गिल्टी प्रूव्ह झालात तर 5 वर्षाची शिक्षा आहे. आणि ती डेथ झाल्याच्या नंतर तुम्ही जर इफ यू आर फ्लेड अवे, ओके, if you are flying from that particular scene, then you will be punished with 10 years. Then who will stop to get the punishment of 5 years? The question is that who will, because accused आहे, obviously गाडी आहे, तो दिसतोय, ते सगळं लक्षात येते, तो प्रूव्ह होणारच आहे गिल्टी. यात काही जास्त विषय नाहीये की तो गिल्टी प्रूव्ह होणार आहे की नाही होणार आहे. ठीक आहे, त्याच्यामुळं ही जी पनिशमेंट आहे 10 इयर्सची, हा, बाय इम्पोजिंग दिस पनिशमेंट, by incorporating this section, we cannot achieve the social justice. Here I want to tell you, because आणखीन बघा एक सगळ्यात महत्वाचा प्रश्न येते की जे क्रिमिनल ज्युरिस्प्रुडन्स आहे ना, स्टेट आहे ना, स्टेटला प्रूव्ह करू द्या. इथं तुम्ही सांगायला, इथं तुम्ही काय इनडायरेक्टली यू आर मोटिवेटिंग दॅट पर्सन टू कम, not directly. I'm not telling these 2 sections are direct. These are indirectly. Indirectly, you are telling that if you come, you will be punished with 5 years. It can be. So that's why I have incorporated this slide also, that why such provision is incorporated, because to enforce moral responsibility. ठीक आहे, moral responsibility enforce करतायत, पण fear create करून. ठीक आहे, जर सापडलात तर 10 वर्षाची शिक्षा मिळेल. स्वतःहून या, 5 वर्षाची शिक्षा मिळेल जर प्रूव्ह गिल्टी झाल्यावरती. पण तो पर्सन काय करेल, तो न सापडण्याचाच प्रयत्न करेल ना. ठीक आहे, तर त्याच्यामुळे आपण काय म्हणतो की फिअर क्रिएट करणं ही चुकीची गोष्ट आहे. अँड यू आर नॉट प्रमोटिंग फॉर द मेडिकल असिस्टन्स ऑफ अ ग्रीवियस हर्ट, इफ दॅट विक्टिम हॅज गेटन द ग्रीवियस हर्ट और एनी इंजुरी. डेथच्या नंतर काय करणार तुम्ही हे सगळं करून? ठीक आहे, डेथ झालेली आहे, तो रिपोर्ट करतोय that he will in future he will proven guilty, if not guilty then no problem, if he will proven guilty. कारण ही गोष्ट काय मर्डर नाही. ओके, दिस इज अ रॅश अँड निग्लिजंट ड्रायव्हिंग, दिस इज नॉट अ मर्डर. त्याच्यामुळे हे जे ऍक्ट आहे हे होऊ शकतं, कोणाच्याही हातून होऊ शकतं. although this is not a correct, but it can be happen. Okay, so possibilities are there, and not only one factor is responsible for this. Okay, there are many factors, that roads are not good, there is in night we can't see. Okay, or fog is also there. So by combining all these factors, just I want to focus on just I want to light on this thing, that the punishment is not a justifiable and the punishment should be changed. Okay, and this is a self-incrimination and indirect self-incrimination. Okay, so there is so as we know, this section is incorporated, they have their different point of view. As per my perspective, this is insufficient, or this is not a balancing. Okay, the discussion will go on this will be continue on this particular topic, but what I think, just I have shared my point of view. Your point of view can be in a positive way, but it should but you have to give the proper reasoning, then your point of view will be proven. Okay.
Thank you very
बोलू
much,
मॅडम.
ma'am. Thank you for the question. It was a good discussion on the both the sides, but what I think was it was on the objective of the theoretical section which is given and its practical possibilities, which Madam was saying from the accused point of view. Of course, this was a discussion on this point. If anybody else want to take participate or raise any question, please raise your hand. Mr. Okay, Madhura Prayag. Madam, please you can participate.
Yes, madam. Yes,
Yeah.
madam. I can ask about drink and drive cases,
Okay.
and who is a drink, and he or she knows that um, that driving is not sufficient in that situation. Then what is the punishment for such persons?
Okay, so basically, drink and drive comes under the recklessness, because in a drink and drive, that particular person is with knowledge he is doing that particular act. Section 185 of the Motor Vehicle Act covers the punishment, and the punishment of this offense is up to the 6 month of imprisonment, and the fine is up to the 2,000 rupees. Okay, and if that particular person is doing that act again and again, it means for the subsequent offense, the punishment will be for 2 years, and the fine is up to the 3,000 rupees.
And in new BNS there is no provisions, madam.
No, BNS hasn't given any provision of drink and drive, but the Motor Vehicle Act 1988 has given the provision about the drink and drive.
Okay, ma'am.
Okay. Any question?
Any last question if it is there? Okay, I think, ma'am, yeah.
Madam, if Javalki sir has to put his opinion before the students, he should be allowed, madam, please.
Yes, ma'am.
Javalki sir, I don't know his surname actually.
Zavdekar sir. Yes, sir. Yes, ma'am.
Javalki sir, if we want to talk, interact
So much.
on same
Uh,
issue, he
when
should be allowed,
when
please.
I am so thankful to all of you. परंतु ठीक आहे, माझं थोडंसं मत भिन्नता आहे, परंतु इट्स ओके. त्यांनी मॅडमनी आपला पर्स्पेक्टिव्ह सांगितलेला आहे. परहॅप्स आय मे नॉट बी अग्रीइंग विथ हर, बट दॅट्स ओके, फाईन. माझं असं मत होतं की रिपोर्ट करणं जे आहे.
हा, if your view you want to put before the students, please sir.
हा मॅडम, नाही स्टुडंट्स समोर ठीक आहे, मी बोलतो. म्हणजे जर आपल्याला जर काही वाटत नसेल तर आय स्पीक.
No, sir. In
It's
fact,
okay.
this is a healthy discussion platform for
Right,
discussion on
thank you so
legal
much.
provisions.
थँक्यू सो मच. थँक्यू सो मच. माझं मत असं आहे त्याच्यामध्ये की बेसिकली हिट अँड रन केसेस मध्ये काय होतं की बेसिकली इरिस्पॉन्सिबली आपण आपल्या नागरिकांचे कर्तव्य न बजावता आपण काय करतो, ऍक्सिडेंट करतो. आणि खरी गोष्ट आहे की बाय स्टँडर्ड्स लिंचिंग करतात, मारहाण करतात. त्याच्यामुळे सुद्धा बरेच ट्रक ड्रायव्हर्स किंवा इतर जे हे ते पळून जातात. ही खरी गोष्ट आहे. परंतु पळून जरी गेलं तरी मूळ मुद्दा असा आहे की आपलं सिटीजनचं कर्तव्य असं आहे की माझ्या हातून हे असं झालं. त्याचा अर्थ असा नाहीये की आपण कमिट करतोय ते. हे कमिट माझ्यावरचं जे काही चार्जेस आहेत ते चार्जेस प्रूव्ह होऊन मी गिल्टी आहे की नाही हे कोर्टमध्ये सिद्ध होणार आहे. त्याच्यामुळे पोलीस स्टेशन मध्ये मी थोडंच कमिट करणार आहे की माझ्या हातून क्राईम झालेला आहे. मूळ मुद्दा असा आहे की एखाद्या वेळेस चालणाऱ्या व्यक्तीकडून सुद्धा होऊ शकतं किंवा दुसऱ्या व्हेकल समोर आडवं आलं त्याच्याकडून सुद्धा ते चूक होऊ शकते आणि त्याच्यामध्ये माझं हिट होऊ शकतं व्हेकल. म्हणजे पॉसिबिलिटी दोन्ही बाजूनी आहे. मुद्दा आहे की माणसाने जो कोणी ड्रायव्हर आहे त्यांनी पळून जाऊ नये याच्यासाठी ते 10 वर्षाचं पनिशमेंट आहे. जरी तो पळून गेला तरी तो अक्यूज तर होणारच आहे. त्याच्या नावाने रजिस्टर्ड आहे व्हेकल तर रजिस्टर्ड आहे. व्हेकल रजिस्टर्ड आहे. कोण केलं ऍक्ट हे काही पोलिसांना शोधून काढण्यासाठी फार मोठी गोष्ट नाहीये. सो इट्स नॉट अ बिग प्रॉब्लेम फॉर पोलीस टू इन्क्वायर अँड सी हु इज द ओनर ऑफ द व्हेकल. नाही का सर, तुम्ही पळून जरी गेलात तरी तुम्ही अक्यूज होणारच आहात. तुम्ही जरी नाही पळून गेलात तरी अक्युजच होणार आहात. पोलीस स्टेशनच्या समोर जाऊन तिथं जर समजा तुम्ही हजर राहिलात तर ऑन द कॉन्ट्री तुमचं जे काही ऍक्ट आहे तो ऍक्ट तुमचा दाखवतो की तुमचं इंटेन्शन क्लिअर आहे. तुमचं गिल्टी माइंड नाहीये किंवा गिल्टी इंटेन्शन नाहीये तुमचं, किंवा तुम्ही तुमच्या मनामध्ये चोर लपलेला नाहीये. होऊ शकते. ऍक्सिडेंटचा अर्थच
And
असा आहे की
sir,
ती दुर्घटना आहे. जी घटना आपल्याला नको असते अशी घटना आहे ती, नाही का? इट्स नॉट
and we can
अ
say,
इट्स अ
sir,
हा.
yes, sir, he can be protected
हे
from mob
प्रोव्हिजन असं
lynching
काही
also.
स्ट्रेंथन करता इनफॅक्ट, असं माझं मत आहे बरं का. दिस इज माय ओपिनियन.
Okay,
Perhaps you might not agree with my opinion, but then this
No,
is
no, sir.
what.
The very object of this section is to safeguard the life of the person who is on deathbed. He should be
True.
protected. That's why
That
if it
that
is,
that ma'am, may I add one thing to it? That section should be always read with the motor vehicle section provisions.
of
yes,
course.
yes.
मोटर व्हेकलचे प्रोव्हिजन्स काय आहेत मॅम, की तुम्ही मेडिकल एड त्याला द्यायला पाहिजे, त्याला बाकीच्याही गोष्टी करायला पाहिजे. म्हणजे इनफॅक्ट तुम्ही काय करायला पाहिजे, त्याला पहिले घेऊन जायला पाहिजे हॉस्पिटलला, मग रिपोर्ट करायला पाहिजे पोलिसला. असं प्रोव्हिजन आहे, असं माझं मत
And
आहे
in
बरं का.
fact, sir, even the driver who has hit, he can also be protected from the mob lynching. If
Maybe,
he
yes,
goes
yes,
for reporting, na, it will be a protection for
exactly,
him. But it has to be
exactly,
understood in a very noble vision
exactly.
which the lawmakers have given.
एक्झॅक्टली. म्हणजे असं माझं मत आहे. पण तो आता आता आय डोंट नो, म्हणजे प्रोटेस्ट काय झाले, प्रोटेस्ट झालेले आहेत ही खरी गोष्ट आहे. ट्रक ड्रायव्हर्सनी संप केला होता ही खरी गोष्ट आहे. त्याच्यामुळे आता ते सेक्शन होल्ड मध्ये असेल असेल
आहे
आहेच.
sir.
ज्या अर्थी तुम्ही म्हणताय
I
त्या होल्डवरच
आहे
आहे.
sir.
हा आहेच ना. परंतु ते काय एका प्रेशर मध्ये त्यांनी होल्ड मध्ये केलं, परंतु ते प्रोव्हिजन जे केलेलं आहे ते इट इज इन फॅक्ट स्ट्रेंथनिंग द ऍटिट्यूड, की तुम्ही पळून जाऊ नये बेसिकली. हे मूळ उद्देश आहे असावा त्याचा. आणि इट इज स्ट्रेंथनिंग इनफॅक्ट, इट इज इनफॅक्ट गिव्हिंग अ पॉझिटिव्ह साईड टू द आयपीसी, म्हणजे अर्लियर आयपीसी और भारत जे काही न्याय संहिता आहे त्याला एक पॉझिटिव्ह बाजू देऊ लागली असं माझं मत आहे बरं का. सो येस, थोडस म्हणजे माफ करा मी जरा थोडं स्पष्ट बोलतोय, परंतु मला असं वाटलं म्हणून बोललो मी.
नाही सर,
थँक्यू
त्याला
सो मच
प्रोज अँड
फॉर
कॉन्स
गिव्हिंग मी
आहेतच
ऑपॉर्च्युनिटी.
आणि दोन्ही बाजू तपासल्या पाहिजे आपण.
Yes,
and
yes. Thank you
students are
so much for
always
giving me
respected.
opportunity. Yes, and thank you again calling me back again to air my views. Thank you so much.
Thank
I'm
you.
grateful.
Madam, will sum up the class? Shubhangi madam,
Yes, ma'am.
will sum up the class? Shall we conclude, madam?
Ma'am, yes, ma'am. Yes, I cannot find anybody's hand raising. That means questions are not there. So I think we can conclude. And in the conclusion, I would first of all like to thank very much today's resource person, Shraddha Choudhary madam. Of course, she has very nicely and intricately studied that particular section, and along with her own justifications and provisions, and very colorful slides are given for the presenters. So thank you very much, ma'am, for giving us and enlightening us on this particular legal provision, along with good judgment readings and good pictures. Thank you very much. I would also like to thank our principal, Dr. Poonam Nathani, madam, for arranging this and giving us, supporting us every time in all the activities which are conducted in the college. Thank you very much, ma'am. And last, and of course, I would, it's my duty, first of all, to also thank from the bottom of my heart to the main inspiration of this particular activity, that is respected advocate Shri Bajpayee sir. Of course, he's always, and he's going to listen this particular recording also, and he's going to appreciate the teacher, of course. So I thank him for always guiding us, inspiring us, and also supervising us for proper conduct of all the activities. Last but not the least, I would like to thank all the teachers and especially all the students at the evening time, but you all are connected in this particular meeting with all your positive inputs. Thank you very much for being present and active presentation, active attendance. Thank you very much, ma'am. So with your permission, may I conclude with the meeting, ma'am?
Yeah, sure, ma'am.
Thank you. Thank you, everyone. Thanks, Shraddha, madam.
Thank you, madam.
Thank you, Kokni sir. Please, we can end the meeting, sir.